And we're live.
All right, we're live. It's Paul Reed and Jason behind the scenes. My Ed McMahon here for another live feed read segment. Thanks for being here. This topic today, and again, it's not scripted, is basically beware of dog signs. All right, so first and foremost, before I even get into it, I think people, Jason, think if I put a beware of dog sign on my property, that if my dog bites somebody, I'm kind of indicating that I knew my dog was vicious and had a propensity to bite someone. Therefore, I'm more apt to get sued and lose. As you're going to see today, that's just the opposite of what truly happens and how a dog owner is actually protected from suit when or if their dog bites someone and they have the beware of dog sign up. How about that? All right, so there's really two statutes. It's 76701 and 76704 are dog bite statutes. And basically, 01 just says the owner of a dog shall be liable for any damages done by their dog to a person or an animal. Okay, and so that means if your dog were to run into somebody and knock them down, you could be liable. The 04 statute is if the dog bites somebody. So they're basically similar or the same in that it encompasses your dog harming someone else either by jumping on them, scratching them, or biting them. All right, and so here's the statute. It says the owner of a dog that bites any person while such person is in public place or on private property, including the property of the dog owner, is liable for damages suffered to the person bitten, regardless of the former dog's propensity to be vicious or not. There are a couple exceptions. One is if you provoke the dog, i.e. you're hammered and you're in somebody's house or wherever, and you go up and start messing with a dog and he bites you, then the dog owner can use that to say, look, my dog bit Jason because he was antagonizing my dog, or this is what is important and why every single person needs to hang up the phone when we're done here, turn off the computer if you have a dog, big or small, and go to take your pick, Walmart, Target, Dollar General, or otherwise, order it online for you millennials, a beware of dog sign. Why? If you post a beware of dog sign in a prominent location, on your fences, by your front door, and your dog bites someone, you cannot be sued. You are not liable.
Could you get like a collar with like a sign that hangs from
I don't know if
like
the Miami Hurricanes gold chain interception collar fits that the statutory requirements.
All right.
But bottom line, put that beware of dog sign somewhere near your front door. And if you have a fence on both sides, and even if you invite someone onto your property and your dog bites them, you cannot be sued. All right, so let's see. Of course, I have a couple of cases that provoked discontent in the office today when we discussed them. So here's the first one. And what we're going to do is, in civil law, there's the plaintiff and the defendant. And of course, the plaintiff is, in these cases, the person that was bit, and the defendant is the dog owner. All right, so this one, just by way of the dog owner here, was the Nobles. And here's the Yorks. And this happened down in the 4th District Court of Appeal, which, remember, basically Miami-Dade and Broward is the 3rd District. And then about West Palm Beach to Daytona, a little bit around there, is the 4th District. So it happened on the east coast of Florida, somewhere in that general area. So what happens? The plaintiff, which is the Yorks, they call up the defendants, the dog owner, the Nobles, and say, hey, we want to come and buy a product from you. These are called jockey silks. I don't even know what that is. My thought would be some underwear, but I don't know. So the defendant, Miss Noble, says, okay, well, listen, come on over. I got a shop in the back. If you knock on the door and I'm not there, I'm probably back there. Go around the house, the building, and then I'll meet you back there. So the plaintiffs, they will knock on the door. She's not there. They start walking around the house, and there is a gate. Now, guess what? On that gate they had beware of dog sign, both sides. That was not in dispute. And so the wife, because it was husband and wife, goes to open the gate.
With the wife of
the plaintiffs.
Okay.
Yeah, the Yorks were husband and wife.
Got you. Okay.
So they go to open the gate to go around to the structure in the back, which she used as her business, basically a garage. And the dog lunges up and hits the gate and kind of slams it on her. So then she goes to grab the gate to close it. The dog gets a hold of her hand, and there's our dog bite.
Okay.
So, of course, the plaintiffs, the Yorks, Mrs. York specifically, sues the Nobles for the attack. I've got to back up because what is important that I kind of left out is the defendant, the Nobles, actually told the Yorks, hey, we've got bad dog signs or beware of dog signs on the fence. Don't worry about them. The dog's okay. You can come on back and you don't have to worry about it. He doesn't bite people.
That doesn't change anything?
Well, we'll see.
Okay.
But that's important to the story.
Yeah. Okay.
Okay, so she basically told the people, don't worry about the dog signs. Come on back.
Okay.
So she gets bit, and we're back to this is like Quentin Tarantino. I go back and forth.
Okay.
So we're back to she gets bit, she sues them, and the defendants, the Nobles, the dog owners, file basically a motion for summary judgment, basically asking the judge to throw the case out based on this 767.04, the dog bite statute. Their position is, hey, we had our beware of dog signs on the fence, and we're not responsible or we're not liable because of that. All right, so the trial judge, which is in the circuit court, agreed. He says, yep, you've complied with the statute, and therefore you're not responsible.
So is this a like where what's kind of right or wrong and what's legal kind of deviate from each other?
Oh, absolutely.
Okay.
Oh,
okay.
Yeah. This is
It's going to be an interesting twisty.
Well, even better on some of these other ones, but yeah, this is simply this is what the statute says, and the courts don't want to just have to interpret little nuances of the facts.
Okay.
Did your dog bite somebody in Florida? Then you're responsible. It's called strict liability. However, if you have this beware of dog sign on your fence, then you're not.
Gotcha.
So that's the courts have wrestled with this for years, and the Supreme Court, because this gets to be a Supreme Court case, says we're done. This is bright line, what they call it, a bright line rule, and this is it.
Okay.
So the judge does throw it out. He says dismissed. They have their sign. Well, the 4th District, which is in West Palm Beach, says no. This is what they call the doctrine of equitable estoppel, meaning, well, yes, they had their sign up, they complied with the statute, but what? Why, Jason, I'm going to ask you, why is the defendant, the dog owner, liable in this case? If they are found to be liable by the Supreme Court.
I mean, my guess would be that she told them to disregard the signs.
Bam!
Okay.
That's it.
Okay.
So I'm going to make a long story short,
All right.
and that's it. They said, no. You can't have a beware of dog sign up on your property, but then tell someone, don't forget about it.
Right.
You know, that doesn't work. And it says, let's see. Oh, yeah. A dog owner who tells a victim to ignore the bad dog sign, beware of dog sign, and pretend it does not exist is not providing a genuine, effective, and bona fide notice, which is required under the statute. So, what is that? Go ahead.
I guess, are they arguing that they didn't meet the qualifications of the statute because...
No. They're saying basically what you said. By telling them ignore the sign.
Right.
That's what got her. So what do you not do, Jason, if you have a dog and you're going to have a party, you're going to have guests come over, you're going to have a delivery, what do you not do?
Tell someone to ignore the sign.
Exactly. Just don't even talk about it.
Yeah, okay.
Put your signs up and say, hey, look at my cute little dog, or look at my man-eater. That's what you do. You don't say ignore the signs. You don't say, oh, it's okay, he doesn't bite. You don't do any of that, because what happens when you do?
you're in trouble.
Yeah, you're not in trouble. You're on the hook.
Yeah.
All right, that's that case.
Okay.
Now, this one here, oof, this is
So
really...
before you go on,
Okay.
Donna K. Griffith says, "Hi, Paul. Proud of you and your family business." Becky Staley says hi. Jacqueline Reed says hi.
Hello,
Brian
everyone.
Staley says hi.
All right. Well, thanks for watching.
Cool.
Hopefully we'll have more people watching, can educate you, because I think this one's important. I day in and day out, even my staff here, I'm like, have you got your bad dog sign, your beware of dog sign? No. Why? It's stupid. It's the easiest way to protect yourself from a lawsuit from an idiot like me. Oh, and by the way, I think, just for giggles, let's see, who was this? Now, one of these was, believe it or not, it was Morgan and Morgan.
I wouldn't say that.
Well, that's right. Here, this is the dog part. So either
it's
way,
public record, so
it's in the books. All right, so this one. So let's say, which I do and you do, Jason, and everyone watching does, you take your dog to the vet, right? Mm-hmm. Or you take your dog to a kennel for breeding or for boarding or otherwise, right?
Or whatever.
Yeah, and again, we've all done it.
Yeah.
So here, let's go through the players. We've got the dog owner, the plaintiff, or the defendant is Whippleforth. We're going to call that one the defendant. The Huey is the plaintiff, which was a kennel worker. So this person worked for the kennel.
Okay.
All right. So the plaintiff is employed at a kennel in the Ormond Pet and Kennel Club, which, let's see, this is, what district is this? It's a Supreme Court case. Well, I'll get to it, but it doesn't matter. We'll figure it out. So the plaintiff or the defendant takes their dog to the kennel, and Huey, the person bit's duties are bathing, grooming, feeding, exercising, medicating, and so forth, taking care of the dog while you're gone. Well, during one of these walks, the Duke, a killer name for a dog, basically jumps up and down on Huey's, the plaintiff's chest. It's a woman, a female, and so she is able to get Huey off, or get Duke off, and says, sit down, because actually, believe it or not, he was there for obedience school. Well, they may need a new trainer, but that's neither here nor there. But he's there for obedience school, so he does. He stops, he sits down. She, for whatever reason, turns her back. What happens? Yeah, Duke gets a second bite of the apple, so to speak, and he attacks her. Now, it's not funny, but he attacks her and bites her, and of course she's injured. So then, what happens? Huey, the plaintiff, the kennel worker, sues the dog owner, who turned their dog over to the kennel. The question is, as we're here, is whether or not the fact that you've let a kennel watch your dog, and or even a veterinarian, give shots to your dog. Sometimes you drop them off, they bathe them, they give them nails, nail clippers, yeah. They give them shots, they have to hold them, this, that, and the other. And your dog ends up biting someone, as they did here. Veterinarian or kennel worker is what this case was about. The question is what did the trial judge do? What did the courts do with that? Did they find the dog owner liable under the statute, the 767.04? Or do they say, well, in this case, this is a veterinarian, this is a professional, this is someone whose business is dogs, animals, but let's just stick with dogs. Right. Kennel owner, look, I'm paying you to watch my dog while I'm on vacation or otherwise, to feed him, bathe him, clip him, do these things. Does that absolve? Meaning, does that mean the plaintiff, the dog owner, is not liable in that situation? So
.04 is the one that just blanket states that if your dog bites someone, you're responsible, right?
Correct.
Okay.
And the exceptions is you provoke the dog or the bad dog sign.
Right.
All right. And this is another Supreme Court case, because it went through the courts of appeal, where the the trial court granted a motion or let it go to trial in the Circuit Court of Disappeal. So it goes up to the Supreme Court.
So if the dog's under someone's care, the person whose care they're under is not responsible. The owner is responsible.
Oh, we haven't given the answer yet.
Oh, that's okay. All right.
So the question is, when you turn your dog over to a professional, a veterinarian, or in this case the kennel owner, and he harms that person, in this case bites them, are you still responsible, even though this is a professional?
Right.
What do you think?
I would think not, but I don't know. I don't know legally what the law says.
Well, we're going to find out, but
yeah.
I will tell you
I'm
before exactly.
Yeah.
Well, Michelle and Mitch, receptionist, and my paralegal would agree with you.
Okay.
And let's see what the Supreme Court said. Yep. The dog owner is liable, even though these people are professionals, the veterinarian. Yep. And so it says 767 is a strict liability statute. And sorry, it may not seem right. It may be unfair, but you're on the hook.
Wow.
Yes, so that one I don't even have advice for.
Yeah, so
This might be your Miami interception chain.
Yeah.
You know,
Beware of dog.
yeah.
This needs
Instead
to go with the
of
dog.
service dog, you get a sweater that says "Beware of dog." Would that qualify as a sign?
Oh,
I don't know, but that was pretty harsh.
That's rough. So you're gonna want to be very careful when leaving your dog behind, because
Yeah,
man.
honestly, that's Vegas. You're a crapshoot. You know,
wow.
now, I don't know that the vet, the actual veterinarian himself or herself would sue you, because that would look bad. If word got out, that I gave my dog to you and you were trying to give it shots, medication, or do something, and you got bit, that I don't know that if that word gets out, I don't know how long you're going to be in practice. But it is what it is. So, yep. So we lose on that one. The plaintiffs win. The dog owner loses.
Jeez. All
right.
Before you go to the next one.
Yep, shoot. Because I only have one more. Again, we don't want to keep
you're
everybody here forever.
Owen Chastain says, "Can you help me go back in time and not drive drunk on 3 separate occasions, asking for a friend?" I think that's a question for Michael J. Fox.
Well, I missed that. I don't know.
Like the time machine, the flux capacitor.
Right.
I think that's probably a question for Michael J. Fox.
I got you.
Right, yeah.
Owen's our IT guy. We're moving on. I don't know what he's doing. We're dog bites, Owen. Dog bites. All right. That's why Owen has a cat. He ain't got to worry about it. All right. So this one, where's this one? Ooh. Oh, okay. Now I was surprised at this. So dog parks. Everyone knows you got the Saladino dog park right up the street here. You got dog parks everywhere. They have fences and so forth. All right, so you take your dog to a dog park. All right, and the dog parks, and everyone has seen it. Not only do they have the clean up your poop and things of that nature. They have the let's see. This one had a sign in a prominent place right by the gate that basically said, let's see, the 2 signs. They listed 10 or 11 rules, 2 of which were important was rough play and chasing are not allowed if any of the dog owners are uncomfortable with that behavior. Meaning, I'm assuming you go in and there's 3 or 4 people and your dog's roughhousing and somebody says, hey, my dog is elderly or I'm not comfortable with that.
Right.
You need to kind of, get your dog out of here or get it under control. The other one is basically assumption of the risk. Everyone has seen those types of disclaimers on the back of football tickets and everywhere else that you basically enter the dog park at your own risk. You know what I'm talking about?
Yeah.
Okay. So, of course, the plaintiff here is Miss Davison. She's the one who was injured by the dog. And the defendant is Miss Berg, so we got plaintiff, defendant, and so what happened? So the plaintiff, Miss Davidson, is an avid animal enthusiast. She actually volunteers at the Humane Society, and part of her jobs are monitoring this dog park that's kind of part of the Humane Society's area in a fence. So she's been there 2 or 3 years. when the defendant brings their dog to the park. And ultimately, what happens in this case, unfortunately, the dog is running around, kind of acting crazy, runs into the plaintiff and breaks her leg. And she has to have surgery, and she sustains some pretty significant injuries.
So I'm guessing she falls down.
I think the dog ran into her. The dog, dog's running around and hits her. Yeah, she probably fell, snapped her leg.
I mean, unless the dog's running at lightning speed, then she'd have to fall down, I'm assuming, right?
Well, it could be a big dog. They don't give a whole lot of specs at how old she is and this, that, the other. Okay. But either way, she breaks her leg as a result of a collision with the dog.
Okay. Did she run from the dog or anything like that? Or?
They don't give you all that, man. They just say basically she got hit by the dog, collided. They don't give you the facts. This isn't a death penalty case here. They just give you briefly what happened. Now, mind you, it is. Let's see. Okay, so the trial court found that the plaintiff was aware of the two signs. That the plaintiff was adequately advised of the risk of entering the dog park, and therefore he granted a summary judgment for the dog owner, the defendant, and booted the case.
Okay.
So he said, yeah, you enter at your own risk was good enough for me.
Right.
All right. So this one is the First District Court of Appeal, which is, remember, Tallahassee, basically the Panhandle. So the First District Court of Appeal, what do they say? Do they say, yes, we agree? Or do they say, no, we don't agree? What do you think?
That was the first judgment, and then it got appealed, and then they reviewed it.
Right, and rendered a decision. Did the trial court get it right that you enter that dog park at your own risk, and if you get hurt, you do so knowing that dogs are in there, and they're with other dogs, and so forth? What do you think?
I think that, like, the previous case where they're pretty much like just across the board, you own the dog, you're responsible, would make me think that they might lean in the same direction, but at the same time there is signage to indicate that you're there at your own risk. So I'm kind of don't know. I'm curious. Tell me.
Okay, well, here's where you go. The statutory purpose of the dog bite statute requires a genuine, effective, and bona fide notice that a bad dog is on the premises. That's the purpose of it. Mm-hmm. Signs that contain digging holes, disposing of dog waste, and enter at your own risk are not designed to warn visitors to not enter the park due to the presence of dangerous dogs.
Oh,
the sign has to say bad dog or beware of dog counts. And I tell you, I used to live by a police officer up in the New Tampa area, and he had bad dog signs on the front. He had a what do you call it? The German Shepherd. Hey, here comes Sugar. Here comes a bad dog. Sugar, come on in here. Here, we'll get back to that. Come here. Oh, there's my bad dog. Oh, yeah, we're going to Mom's. See ya. All right, so he had the bad dog sign. So you can't have this dog, this house guarded by Duke or no. Okay. Bad dog or beware of dog signs. They and that's basically it. That one again had some troublesome because I told Mitch and Michelle this one first before it's really strict liability. There are no exceptions. You have to have that sign, and if not, then you're out of luck. Now the question was, and I don't know the answer. Let's say you're going to a dog park. What if you bring your own beware of dog sign, put it on the fence, you just kind of little hangers, hang it on the fence by the gate, and then you go into the park and let your dog play. Would that count?
I don't know.
I don't either, but I can tell you this. I'd rather have that sign hanging up there than not.
Yeah, because they may say that, like, oh, if you knew your dog was bad and couldn't be around people,
that's the misconception. That's why people don't get the beware of dog sign because of that thinking. Huh. That thinking is you put a beware of dog sign up because you know your dog is a bad dog.
Right.
Stop.
Okay. Yeah. Okay.
That is just you have the beware of dog sign because legally you can't get sued.
Right.
I mean, so if you don't have one, then
Okay.
then that's all. Then don't
Then
blame.
I am
Hey,
curious.
when
Not
Reed
that I wanna go test the
when
theory.
Reed comes knocking, I don't want to hear it because Reed told you to put a sign up.
Yeah.
All right,
Not
what do you
that I
got?
want to test the theory,
Go ahead.
but it is. I am interested to know whether or not hanging your own "Beware of Dog" sign
Oh.
would matter.
Well, hopefully, if that would make it here sooner or later, because
Man.
if you won at trial, the other side's going to appeal, and if you lost at trial, you're going to appeal.
All right.
But it just says, and this is a dog. They had signs, so actually, I think the dog park should put a "Beware of Dog" sign up. That's the easy solution. Put a "Beware of Dog" sign up at your dog park, and then we're all good.
Interesting.
Yeah. So if you know of a dog park, you may want to contact. Say, look, if you put this "Beware of Dog" sign right here by the gate, all the people using it are protected.
So ultimately, their ruling was that those signs don't constitute warning signs.
Correct.
Okay.
Correct. That's why you see the funny ones that a little different, but this house guarded by Smith and Wesson, or whatever.
Right.
No, it's very. It is. They've just made it easy. You put that "Beware of Dog" sign up, barring you doing the case earlier about forget about it,
Yeah.
don't worry about it. You're fine.
I wonder if like a "Beware of Human" sign might be.
Well.
Maybe applicable.
Oh, Shuggy!
Oh, no, I'm sorry.
Jason stepped
I'm
on
sorry.
there.
I'm sorry.
All right. So, but anyway, we rambled on long enough.
Cool.
That is your "Beware of Dog" lesson for the day. Couple of things. I'm going. Ryan will be here at 10 o'clock next Friday because I'm going to visit with my daughter Brittany in Nashville. And of course, when I say visit, party.
Right.
And a shout out to old Brittany. She got her nursing degree, Bachelor of Science in Nursing, in December, and chose a heck of a time to COVID-19 to become a nurse. But she's up there battling in the Washington D.C. area.
Kudos to her.
And I'm looking forward to seeing her. I love you, Brittany. And Jason, anything
Education,
else?
yes. This
Yeah.
video is for the purpose of education, not legal advice. It's just awareness and entertainment.
Oh yeah. Oh, and again, Jason's my Ed McMahon, and I think he's going to be spotlighted next week with Ryan, so he'll be on this side of the table.
Okay.
You guys can meet him. That'll be cool. Other than that, Brittany.
Subscribe, like.
What is it?
And share.
Subscribe, like, share, and I'm heading over now. We're done. I'll be there in about 3 hours, and have the beer cold. See ya.